Hi, friends. Welcome, friends, colleagues, all who are joining. We are very glad that you have registered for our webinar and have joined us. We will be starting shortly, but perhaps just another minute or two as I see some are still joining the webinar. But to get us moving, my name is Ramadan Iloazi. I'm head of research at the Kosovo Center for Security Studies. And it is my pleasure to open this webinar with friends and distinct colleagues um, who will be sharing their thoughts on a topic of quite essential relevance, I would say, not only to Kosovo, but a larger context in Balkans and Europe. So this webinar is dedicated to the Kosovo Specialist Chambers as a webinar of reflection on this institution, what it has produced so far, looking at the politics around this institution and the workings of the specialist chambers, potential ramifications of the verdicts that will be issued, perhaps towards mid-May. I'm assuming that's the expected deadline, right? Unless there is a request to postpone from the judges the verdict. But so now that the process is completed, we thought we can have a joint conversation on this issue. I am joined today by Dr. Gazim Visoka, Associate Professor of Peace and Conflict Studies at Dublin City University, as well as Dean of Research, right, Gazim? Afrodita Suda, Executive Director of Community Building Mitrovica, an organization who has worked for decades on issues of transitional justice and peace building. And Afrodita will bring in our discussion the community perspective around specialist chambers. We have Dr. Armand Bekay, who is joining us from Uppsala in Sweden. Armand is researcher at the Department for Peace, Department of Peace and Conflict Research at Uppsala University. And last but not least, Dr. Robert Muharremi, who is joining us. I'm assuming Robert here from Pristina. Robert is a widely respected legal expert, but not only. Robert is assistant professor at RIT Kosovo and American Academy of Technology in Tirana. I am also happy to see colleagues who have joined in this webinar, including Dr. Aidan Hehir, who has also worked on this. So perhaps later on we can also hear from him as well. But without further ado, how we will go about this webinar is that each of my colleagues will share about 10-15 minutes of their remarks on the topic. And then we will open for questions and comments from colleagues following this webinar. And without further ado, it's my pleasure to invite Gazim or Dr. Visoka for his opening remarks. Gazim.
Great, thanks, Donny, and hello, everyone. So I suppose in my brief remarks, I'll touch upon couple of questions or points with regard to the sort of impact of the specialist chambers on victims, society, and I suppose on peace. So back in 2017, I published perhaps the first flagship study on the Kosovo specialist chambers, which focused on assessing its societal impact. I suppose from the outset, back then, almost 10 years ago, there were doubts that the court was sort of established on an anti-KLA mandate, mono-ethnic nature, but there was openness to seeking truth and justice for the alleged crimes, especially to address the allegations of organ trafficking. Now, the fact that the court since then has shifted its focus from Marty report and the alleged organ trafficking to the conduct, I suppose, of the liberation warfare, it has created a strong public reaction in Kosovo in a negative sense. So there's a public perception that the specialist chambers have ended up being a geopolitical instrument for disciplining elites, balancing guilt, but also focusing on negative aspects of the Kosovo Liberation War. So transitional justice processes, as we know, in a narrower sense, they try to bring justice to victims or a measure of closure for what has happened. But also broadly, they seek to strengthen the trust in the judicial systems and the rule of law. I suppose if we take this as a basis to look at the specialist chambers, we can conclude preliminarily that in a narrow sense, it's hard at the moment to assess whether the specialist chambers have provided justice to the 140 odd number of victims and their families. The extreme witness protection measures and secrecy surrounding their narratives, their who they are, has really made very difficult to engage and know their stories and know and connect with those victims. There's been a lot of questions also about the motives and the background of testimonies, especially the evidence that was brought in from the Serbian structures, state structures, which has undermined the credibility and legitimacy of the victim community, one could say. So the sense that I have is that Kosovo public has not increased sympathy and support for the victims that were sort of that the court support was supposed to kind of bring justice. The secrecy and non-transparent management of victims has perhaps stigmatized them even more. And beyond that, the court's refusal to consider cases of Kosovo Albanian victims and political prisoners, it has added trauma to a wider community of victims in Kosovo. So in that sense, it's hard to really ascertain that the court has had a positive impact on the victims or a closure for them. In the broader sense, at the same time, when the proceedings of the court accelerated, Kosovo has also accelerated its war crimes trials, but they've been overshadowed by the specialist chambers. There have been a lot of trials, a lot of indictments against crimes committed during the war in Kosovo, but they've really made or become sort of secondary of nature, which again brings question to the impact of the court. And then the other question is, what about the sort of narrative and the whole sort of prosecutor's case? And I would say the following. Having read the prosecutor's case and also listened to their questions, my sense is that the court sort of has a very high perception or bar of justice, and it actually targets liberation movements, self-determination movements. So beyond Kosovo, it tends to sort of project a model of how warfare should be conducted. So if you kind of flip the narrative that it is implicit in the prosecutor's case and also the questions, one gets the sense that prosecutors would have wanted Kosovo Albanians not to resist Milošević's regime, not to mobilize for resistance, obey oppression, pursue peaceful, non-violent, non-military politics, regardless of discrimination and collective harm. And then even during the sort of liberation warfare, the bar is very high in terms of moral, normative, and sort of a legal framework of how KLA should have conducted their affairs. So basically, it kind of sets the bar very high that no liberation movement, no armed struggle, no just war will be able to meet. And the theory, I think, behind specialist prosecutor sort of case is very much obedience, peaceful conduct of affairs without any regard to agency, resistance, and the need for change. So the message it sends beyond Kosovo is that don't resist oppression, don't seek self-determination, don't fight for your rights, but decide to fight. But if you decide to fight, you should not harm anyone, either discursively or politically, and don't engage with sort of collaborators, traitors, or whatever categories that are on the way in that struggle. So this is a great model for authoritarian regimes. They love that sort of that sort of lack of resistance and acceptance to authority. So I think we can talk more about the narrative, but I'm afraid it is a case against liberation movements, self-determination movements beyond Kosovo. Then the final two remarks I would like to make concerns sort of the impact it's having, I'd say, in Kosovo and broader region. and maybe Afrodita can also touch upon that. But my sense is that the specialist chambers have not really improved ethnic relations in Kosovo. They haven't really brought communities closer. They haven't really mended relations. On the contrary, there's more intra-Albanian fragmentation, more inter-ethnic division and polarization when it comes to the past. And if, let's say, the verdict results in conviction in the coming weeks and months, it will open a new front of diplomatic warfare between Kosovo and Serbia, of revisionist narratives, which will harm peace and stability in the region, something that runs against, I think, the philosophy of the court in itself, which is to kind of uphold the political, peaceful political order. And then the final remark I'd like to make is concerns the specialist chambers, I think, have resulted in loss of trust in Kosovo on international justice, but also in international allies. When the specialist chambers were established, the promise was that Kosovo's Euro-Atlantic future would be unlocked, accelerated. None of that happened. We're not closer to EU, closer to NATO, Council of Europe, or any other organization. So I think this has set a negative precedent when it comes to making concessions. And my fear is that this is also being reflected in Kosovo's resistance to establishing the Association of Serb Municipalities, because the fear is that it will be something promised and then deliver something else, and it will change its mandate. So overall, I think the legacy of the special chambers is mixed. It's early to come to a conclusion, but early signs are that it has not really achieved what it has intended. On the contrary, it has opened up new avenues for contestation and disagreements.
Thank you so much, Gazim, for your opening remarks. It's very interesting because at least some of the speculation around the process of establishing specialist chambers back in time were also linked to potential appeasement or concession to external actors. And now with everything that's happening with full-scale invasion of Ukraine and all of that, it begs the question in terms of unveiling the very process of how it came, I think, to also to the establishment. And as you said, I think this is very much a sentiment shared in Kosovo that in the concluding speeches, the case the prosecution made was yet more general against liberation movement, and it was read as though, as you stated, that Milosevic's regime should not have been in a way maybe resisted at all. Thank you, Gazim. It's my pleasure to invite Robert for his remarks. Robert also recently wrote, and not only recently, he wrote quite a few times on this topic. But Robert brings both more legal, but as well as a perspective on grounded in peace and conflict studies. So, Robert, the floor is yours.
Well, thank you, Dani, and hello to everyone. You just built the perfect bridge, actually, because I wanted to shed a bit of light to the process that has led to the establishment of the specialist chambers and its political and legal implications today. I think it's very important that the origins are always kept in mind. Yes, we all think that the Marti report approved by the Council of Europe 2011 is the origin. Actually, it's not, because the Marti report was triggered by the so-called Kosachev motion back in 2008. It was April 15th, 2008, that Konstantin Kosachev, who was a high-ranking Russian delegate to the Council of Europe and also a member of the Russian Duma, authored a motion to start investigations into what Carla Del Ponte in her book wrote, that there were allegedly organ trafficking and organ harvesting by the KLA during the war. I mean, Carla Del Ponte was the chief prosecutor of the ICTY. and the ICTY dealt with Limay and Haradinaj. So if there were such allegations, the ICTY could have investigated these allegations. But Carla Del Ponte had grudges with the US because she felt that the US had not supported her investigations at the ICTY, sometimes even frustrated. So it was more kind of an, put it this way, anti-American or anti-US administration allegation that, look, I mean, you have frustrated certain investigations. So what happens? Barely 2 months after Kosovo declares independence, Kosachev and some 14 other members of the Council of Europe support this motion to investigate into the allegations which were made by Carla Del Ponte about allegedly organ trafficking by the KLA. Now, who was Kosachev? I just mentioned it, a high-ranking Russian delegate, and this motion was supported primarily by the Russian and Serb delegates and some other individual members. Now, Kosachev is on the US sanctions list since 2018. And because of his involvement in the Ukraine war, he's actually also the author of the so-called Ukrainian biochemical conspiracy that allegedly Ukrainian soldiers are being doped in Ukrainian labs to become super soldiers. And he is also involved in Russian allegations about Ukrainian organ trafficking and harvesting since 2014, and especially since Russia is, quote unquote, trying to liberate the territories in Ukraine. So he's a spin doctor, but he was actually very instrumental in triggering and putting on the Council of Europe's agenda Carla Del Ponte's allegations, which then materialized into this investigation by Dick Marty. So who was Dick Marty? Dick Marty actually was a Swiss. But he was not, I mean, while you can perceive it as a neutral person, he wasn't really neutral because he had already previously for the Council of Europe conducted investigations about CIA renditions and secret prisons. So he had a slightly, while idealistically, let's say, pro-human rights approach, he also had, like Carla Del Ponte, by the way, both Smiths, also a pretty anti-American approach. So it was under the auspices of the Council of Europe that the Russians actually were able to initiate and put on the agenda a framed narrative that would actually result in the Marty report. Now, if you look at the Marty report, which came out in 2011, which was approved as such, how does it portray actually? It's not only about KLA being accused of organ trafficking and organ harvesting and other heinous crimes. If you read the report, it's a typical strategic narrative that wants to frame and shape opinion and to direct attention to certain events in a manipulative way. I mean, how is Kosovo portrayed? It's actually a lawless region which is dominated by mafia-like clan structures. I mean, as if we would be living in the Middle Ages. And Kosovars are governed by the Kanun, and all the KLA operative zones are basically criminal zones divided between criminals. KLA is, in essence, a criminal organization which is involved in, among others, organ harvesting and organ trafficking. And of course, the international community has not done its job because they should have prosecuted and they should have investigated and brought to justice, but they haven't done so. But now they have a chance to do so. So if you look at this narrative, it is a typical strategic narrative designed to frame. Now, any evidence? No. The Marty report, when you read it, has barely any evidence. It's all hearsay, it's all indications, it's all we think, we consider, but there is barely any evidence for any of the allegations made in the report. It's basically an extended chapter of Del Ponte's book on the ICTY and the Kosovo chapter that she wrote. However, the narrative was out because once you associate the KLA with organ trafficking, I mean, there's an image, and that image sticks in your minds. And truth is not always important as much as is an image, as is a narrative, because that is convincing to us. Now, what happens? 2014, EULEX special investigator Williamson comes out with a report saying, well, we have no real evidence about organ trafficking and organ harvesting. Everything what was written in the report is exaggerated, and maybe there were situations, but even for these limited, less than 10 situations of organ trafficking, we don't have evidence. We have evidence about other crimes, crimes against humanity, war crimes, but the whole narrative anchor of the Marty report, which was organ trafficking, was basically killed by the SITF, the Special Investigative Task Force of the EULEX. However, did it change anything? No, it didn't change anything because the narrative was out there. A process was already going on to establish the specialist chambers. So why does it matter? It matters because apparently today the Kosovo Specialist Chambers is still framed and driven by the Marti narrative, which goes back to this Russian initiative. Why? Well, compare just the judgments of the ICTY in the cases Haradina and Limay with the decisions of the Specialist Chambers in the cases of Mustafa and Shada. If you look at the ICTY is pretty straightforward. There is no joint criminal enterprise. In none of the two cases did the ICTY accept KLA or anything related to it to be a joint criminal enterprise. If crimes were committed, they were committed by rogue individuals. There was no systematic institutional policy to conduct war crimes, crimes against humanity. And in the end, they really legitimized KLA, the ICTY, as a legitimate guerrilla liberation movement. Now, the same organization on trial by the Kosovo Specialist Chambers. What do we have? In the Mustafa and the Shada case, affirmative, it is joint criminal enterprise in both cases. In both cases, the Specialist Chambers confirms there was systematic institutional practice of political persecution, crimes against humanity, war crimes. And in the end, KLA is basically nothing more than a vehicle for a joint criminal enterprise. So diametrically opposed narratives about the same institution, ICTY saying no, Specialist Chambers saying yes. Now, to me, the question is, why do we have such diverging narratives and images? Well, to me, the answer is very clear, because the KSC is really still framed by the Marti narrative, because the judgments in the Mustafa and the Shada case really affirm what is written in the Marti report, but it's completely the opposite of what the ICTY found concerning the KLA. Now, my question is, does this mean that the Specialist Chambers is perpetuating a narrative that goes back to a Russian initiative which was really meant to discredit Kosovo's independence, and not only Kosovo, but also the NATO support to the KLA and to Kosovo? I mean, are we really perpetuating that narrative? I mean, do we unconsciously somehow turn into the pawns of Russia's strategic game to discredit the West by perpetuating this narrative? I would be inclined to answer in the affirmative. Now, the next question for me is also, okay, if we don't have allegations confirmed, and we don't have the evidence for organ trafficking and organ harvesting, why do we then need a Specialist Chambers that is in The Hague, that is fully composed of international judges and prosecutors and registrars? I mean, no single Kosovar can work there. It's all international. Why isn't it possible then that for, I would call them ordinary crimes against humanity and war crimes, that we entrust the Kosovo courts with that? I mean, look at Serbia. Serbia doesn't have a Specialist Chambers. I mean, but Serbia was the aggressor in Croatia, in Bosnia, in Kosovo. However, our war crimes dealt there, they have a special department within their regular courts. They don't have an international court, but Kosovo has one. What does it mean? Is Serbia's judicial system more reliable and credible than Kosovo's, which was developed and established by the UN and by the EU? I mean, all Kosovo judges and prosecutors were selected, appointed, trained by the UN and by the EU. So, I mean, why this motion of no confidence? Now, this leads me to another question. Why is the Specialist Chambers actually targeting only the KLA and KLA members? It's interesting that we have a judgment of the Specialist Chambers Constitutional Court panel that actually has confirmed that the jurisdiction of the Specialist Chambers is not limited to the Marti report. It goes beyond that. Thachi actually filed a complaint saying, hey guys, you're charging me for things that are not in the Marti report. And the Constitutional Court panel of the Special Chambers confirmed, yes, that's correct. And we can do so because the jurisdiction of the court is determined by the law on the Kosovo Specialist Chambers, not in the Constitution, not in the exchange of letters between Kosovo and the EU. They don't define the jurisdiction of the court. It's defined in the law, which was passed by the Kosovo Parliament. And now, in this law, we have a much broader jurisdiction. And I want to read it out, what the court says. If the drafters of the law, meaning the members of the Kosovo Assembly, had intended to restrict the jurisdiction of the specialist chambers to the allegations made in the report, they could have done so expressly in the law, which means it's basically in the Kosovo's hands to determine the jurisdiction of the Kosovo specialist chambers, to limit it to what is alleged in the report or to make it broader. Kosovo decided, knowingly or unknowingly, to make it much broader. Now, what does it mean for the jurisdiction of the court? It means that, and I'm again citing the court, charges, accusations must relate to the report. And that relate to must take into account the context and the content which is reflected in the report, which is dealing with the Kosovo conflict, which portrays an overall worrying picture of the situation in Kosovo. Now, my question is, if that is the jurisdiction of the court to look at the overall situation which existed between 98 and 2000, I mean, was the KLA the only guy in town? I mean, we had Serb army, we had Serb police, we had Serb paramilitary, we had KFOR, we had all sorts of players on the ground who, one way or another, were involved in serious criminal conduct. So if the specialist chamber has such a broad jurisdiction and is not limited to the report of Dick Marty, why do we then only investigate KLA members and not also crimes committed by Serbs? Why don't we investigate if the international community has failed to protect in the period between June and December 2000 when they were acting under Resolution 1244 here? Because imagine you have all these crime allegations and they happen in front of KFOR. I mean, something must be wrong there as well. So is this selective justice? Yes, it is selective justice, confirmed actually by the specialist chambers itself. Why? Well, apparently the Marty report narrative is still framing and shaping the way how the specialist chambers looks at the jurisdiction and is limiting it or illegally only to the KLA. Now, this brings me to my last point. We all know that the law on the Kosovo specialist chambers passed only after an amendment to the Constitution. This amendment to the Constitution had to be sent to the Constitutional Court for review if it's in line with the Constitution. Now, it's very interesting that the specialist chambers also very selectively cite the Constitutional Court judgment, which says, yes, it's okay. I want to read it out. The Kosovo Constitutional Court, in its decision of 2015, when it approved the amendments of the Constitution, wrote very clearly, the international obligations of Kosovo result from the Marty report. And now it's very important to read the details, which outlines a number of highly specific criminal allegations, which have been incorporated into the legal framework of Kosovo. Now, to me, this reads that we have incorporated into the Kosovo legal framework only the specific allegations which were made in the Marty report, and it's only about these specific allegations for which the specialist chambers has jurisdiction. So in my view, the broad interpretation of its jurisdiction by the specialist chambers is completely unconstitutional. No one is bringing it up. No one picks up on this issue. Not even the parliament, no lawyer, no one. Now, another issue which is related to this, because in the same decision, the Kosovo Constitutional Court had to review, does it make sense that all the judges and prosecutors are appointed the way how they are appointed? The Kosovo Constitutional Court just said the following: the appointment of judges and prosecutors to the specialist chambers will be determined by law, so nothing else. However, this law must be in line with the principles of the Constitution and the Kosovo Constitution as such. Very interesting. That's what the court says. Now, what does the Constitution of Kosovo say? Article 104 says, the President of the Republic of Kosovo shall appoint, reappoint, and dismiss judges upon the proposal of the Kosovo Judicial Council. And the composition of the judiciary shall reflect the ethnic diversity of Kosovo and gender equality. Does it mean that the composition of the specialist chambers, which is only international, is unconstitutional and also violating the findings of our own constitutional court? Yes, it is. Now, you can make the argument, but we have an agreement with the EU that we will have all judges being internationals and prosecutors. Well, under our constitution, international agreements are superior to Kosovo laws, but not superior to the Constitution. The Constitution always prevails. So if our Constitutional Court has said the composition of the court will be determined by law in accordance with the Constitution, we cannot have a specialist chamber which is fully and exclusively composed by international judges and prosecutors. Now, this leads me to my final conclusions. Where are we here? I mean, to me, all this doesn't really make sense unless we are really perpetuating unconsciously and not really knowingly a Russian narrative that was aimed at its time to discredit not only Kosovo, but the whole Western world. We have an unconstitutionally broad jurisdiction of the specialist chambers. We have an unconstitutional composition of the specialist chamber. We have a court which has no local ownership. We have a court which has no democratic constitutional accountability. And now my question is, what's the point with this? Why doesn't anyone react? Why is no one in the Kosovo parliament raising this? Because, I mean, it touches upon the very foundations of the state of Kosovo and the Kosovo constitution. So these are my few remarks on this.
Thank you so much, Robert, for this expose, which really brings, I think, a lot of clarity in terms of the legal dimension and arguments. And some of this information, I think, might be new to, or the analysis might be refreshing and new. But we also heard from Kosovo's own ombudsperson institution being highly critical of the cooperation or relation with the specialist chambers. And this, I think, echoes the point that you made about democratic accountability of the court. Now, let me invite our colleague, Afrodita Arsula, Executive Director of the Community Building Mitrovica. Afrodita, the floor is, the digital floor is yours on your remarks.
Thank you so much, Danny. Thank you, KCSS, for this opportunity to speak in this very important panel and a very important topic also. Hello, everybody. As Danny mentioned, I'm speaking today as the Director of Community Building Mitrovica, and my perspective comes from working directly with communities, not only from the theory. In that work, I see how people understand justice, how they react to political developments, and how these things affect relationships between Albanians and Serbs. So I will not focus on the legal details of the court. Of course, we have Professor Mari here and other colleagues that are very good on this. But instead, I want to answer one question: what has this court actually done to communities, and what is its impact? The Kosovo specialist chambers were created with the aim to bring accountability, to investigate crimes from the war, to identify responsibility, and to deliver justice through trials. This is important in any post-conflict society because without accountability, there is a risk that crimes are ignored or denied. If this was done and how this was done, it was presented by Professor Robert, but under others, one of the objectives, which is important, and even the court's primary international supporters, including the EU and the United States, have repeatedly said that the Kosovo specialist chambers should be a mechanism to achieve reconciliation and build a better future. But the key question is not only what the court was meant to do. The key question is how is it experienced by society? And here we see a problem. In many communities, people do not feel that this process represents real accountability. Because accountability is not only about having trials, it is also about people understanding the process, people trusting the process, and people accepting the outcomes. Right now in Kosovo, these three elements are weak. This is shown through research papers also, and and figures that are through those research papers. One of which is the research paper done by Integra, Impunity Watch, and other organizations in 2017, which says around 6% of respondents say they know quite good the work of the court, but in a sense, which was like the 6% that they knew about the court, and we had around 30% which were neutral, and the majority, they didn't know much about the court. So, and even under those 6%, they were thinking that the people tried in this court are there for corruption and misuse of power after the war, which this tells us that the court was actually the people didn't understand the court. They don't read the documents because there was also not so much of promotion of what this court really is doing, or it was also something that the court was not very transparent and not accountable at all. So one of the main reasons for the low trust is how the court is perceived. Many people believe that the court is selective because people see that the court mainly deals with cases linked to the KLA, while they feel that other crimes, especially crimes against Albanians, have not been addressed in the same way. Because of this, they do not see the process as balanced. And when people do not see justice as balanced, they do not trust it. This is also why many people describe the court as political. This does not mean they are analyzing legal documents, as I said, but it means they are looking at outcomes. They ask simple questions: who is being prosecuted, what is missing, and based on that, they frame their opinions. So when they see only one side being addressed, they feel that the process is influenced by politics, not only by law. Another point is that the court has been established under the Kosovo laws, but never has shown accountability to the Assembly of Kosovo, from which was established, nor to the citizens of Kosovo. There is another important issue that affects communities. In law, the court judges individuals. This means responsibility is personal, but in society, people do not always see it that way. In Kosovo, the KLA is not just an organization. It is part of identity, part of history, and part of how war is remembered. So when former KLA members are judged, many people do not separate those individuals from the KLA as a whole. This creates the feeling that group is being judged, not just the individual. It is also important to understand that communities experience this court differently. Example from the Albanian community, people feel that court is unfair. This is because they connect it to the broader history of the war, where they see themselves mainly as victims. On the other hand, from the Serbian community, the court is seen as finally recognizing crimes against them. So we have the same court, but two very different interpretations. When people do not share the same understanding of justice, it becomes difficult to build trust. In places like Mitrovica, this is very visible. It affects how people speak to each other, how they view institutions, and whether they are willing to cooperate across communities. So the court is not only a legal process, but it has social consequences also. Looking forward to the final decisions of the court, I think the decisions of the court will be very important. If there are strong convictions, many Albanians will feel frustration, not because they support crimes, but because they feel process is not balanced and fair. If there are acquittals, many Serbs may feel that justice was not delivered. So in both cases, there is a risk of disappointment and tension. It means that decisions alone will not resolve divisions. They may even deepen them if not handled carefully. So the question is, how has the court helped reconciliation? I don't know what to say, or maybe I would say no, as we haven't seen any outcome of the court on reconciliation. It has divided even the Albanian community itself, because reconciliation requires trust, shared understanding, and recognition of all victims. Right now, these elements are still very weak, and without them, justice does not automatically lead to reconciliation. Thank you.
Thank you so much, Ferdita. And now it's my pleasure to invite Dr. Bekay Armand for the final and concluding remarks from the panel before we open to comments. Armand, are you still with us?
Yes, I'm here. Can you hear me?
Okay. For some reason, I don't see you, so I don't know if your camera is open or not. But
My camera is on, I think. Can you hear me?
Yeah, we see. We
yeah,
see
and
him. Yeah.
now we see you. Yes.
Okay.
Okay.
It's okay.
Okay.
Thank you, Donny.
Yeah.
Thank you, Donny. Thank you, KCSS, for organizing this webinar. And I'm very pleased to see quite a large turnout. A lot of people from various backgrounds and countries interested on this very important topic. And really, I want to commend you, Donny, and KCSS for organizing a webinar on this particular topic. We've had far few webinars and seminars of this kind, but touching upon a very sensitive but a very important topic. And I think we should learn from this to be more courageous intellectually, first and foremost, to tackle such very important issues. I think not just for this particular case, what's happening in The Hague, but with potential very wide ramifications globally, I think. In response to the questions which you posed, Donny, I would want to really limit my remarks on 3 points. I want to raise 3 points in relation to the ongoing or the trial that has come to an end, to a completion now at The Hague. The first one is the issue of individual versus collective culpability. My question here that I pose is whether what we have seen in The Hague in the last 5.5 years has really been judicial precision, really dealing with individuals about alleged individual crimes, or whether we have seen more of a sort of a muddled terrain, trespassing the territory between individual culpability and collective culpability. In building their case, what we have seen is that the Specialist Prosecutor's Office, or the SPO, has somehow tried to sort of divorce the KLA's collective role in the war from the individual criminal responsibility of 4 individuals, Hashim Thaçi, Kadri Veseli, Yakub Krasniqi, and Recep Selimi, right? And according to them, according to the prosecutors, Thaçi et al. Used their senior positions within the Kosovo Liberation Army to build an intricate web of conspiracy, power, and deceit, with a common purpose of acquiring dominance over control over Kosovo. And to fulfill their promise, to their purpose, according to this argument, they allegedly unleashed an orchestrated campaign of killings, abductions, and mistreatment of hundreds of civilians in Kosovo and north of Albania between early 1998 and sort of September 1999, right? So which is during the war, but also after the setup of the United Nations mission and the NATO force in Kosovo, as was also highlighted by Robert earlier. According to the prosecution, the killings were not random, but planned as a means to gain political power, and were organized through what the prosecution has coined a joint criminal enterprise, or the JCE. This rather catchy term, I would say, is used by the prosecutors to describe the alleged criminal network, a notion they advanced to avoid calling the KLA itself the culprit. In international law, as we know, there are elements that differentiate between simple crimes from those of war crimes and crimes against humanity. The latter crimes are categories that stand above random crimes due to their severity and impact, but also because they are well orchestrated by political, ideological, and/or military organizations involving groups of individuals whose common purpose is domination, power, coercive control, and so on. The prosecutor's foundational claim is that Thaçi, with the other 3, were at the helm not only of the KLA, which again is apparently not on trial, but of a secret phantom organization, which they called the JCE, one that used violence to achieve wider political objectives of domination, power, and control over the whole of Kosovo. The distinction between the KLA and the JCE, the joint criminal enterprise, that the prosecutor has referred to has been blurred actually from the outset of the proceedings. If we look at the paragraph 35, for instance, of their confirmed indictment, it states right at the beginning of the trial that in addition to the 4 defendants, there were others involved in this criminal enterprise who were members of the KLA as well as of the Provisional Government of Kosovo, or the PGOK, which was constituted for a brief period in 1999 by senior members of the KLA. The list includes, and I quote, general staff members, PGOK ministers and deputy ministers, KLA zone commanders, deputy zone commanders, and other members of zone command staffs, brigade and unit commanders, commanders and members of the KLA and PGOK police and intelligence services. So the list goes on. Others who aided and abetted included KLA soldiers and PGOK officials, each in their own way contributing to the achievement of the common purpose of this so-called enterprise. And even if there were those who might not have been in the enterprise, who didn't know consciously that they were in the so-called enterprise, they were still, and I quote again, used by members of the joint criminal enterprise to carry out crimes committed in furtherance of the common purpose, together with the JCE members, collectively JCE members and tools, end of quote. So this is the indictment of the specialist prosecutors who allege that they are prosecuting only 4 individuals on paper. They have done so throughout the trial, meddling essentially between the culpability, the alleged culpability of individuals versus the so-called joint criminal enterprise versus actually the Kosovo Liberation Army. And therefore, to conclude this first point of mine, I argue that really the prosecutors have not offered a convincing case that the individuals are on trial alone and not the armed movement itself. This is because throughout the case, the SPO really has muddled the distinction between individual and collective culpability. Now, my second point is in relation to what sort of army or what sort of formation the Kosovo Liberation Army itself was. Was it an amorphous group or was it a formal army? So, and in relation to that, it's also the question of crimes by virtue of a supposed chain of command. Now, to clarify, Thaci et al. Are accused of crimes by omission or by overseeing the so-called JCE. By extension and by virtue of their alleged chain of command responsibility, they are being held criminally liable for any alleged crimes committed in the name of this enterprise. However, an ethical and legitimate question arises as to whether it is reasonable and realistic to expect identical top-down accountability from an informal armed group that is far from cohesively organized and has unclear lines of responsibility. And that is exactly the key premise upon which the prosecutor's case was built from day 0. And that is to seek criminal responsibility from the defendants by elevating the Kosovo Liberation Army to the status of a formal state army. And I echo what Gzim was talking about earlier about liberation movements as well. In his testimony, James Rubin, a spokesperson for the US Department of State during the war in Kosovo, described the KLA as an amorphous organization, quote unquote. Admittedly, this armed formation eventually named a political representative, a chief of staff, and a political director, the latter a title held by Hashim Thaci. However, this was far from a well-organized army. The decision-making process, lines of responsibility, and even the chain of command were patchy, disorganized, and at times even non-existent. Decisions were often made in consultation with regional commanders, akin to a horizontal consultative process rather than a top-down diktat. And to complicate accountability even further still, in contrast to the jurisdiction of the International Criminal Tribunal for the former Yugoslavia, or the ICTY, which was limited to the period of wars in former Yugoslavia in the respective entities of that former country, jurisdiction over crimes in Kosovo extends to September 99, the period following the end of hostilities. This time frame surpasses 12th of June 99, when Kosovo was liberated and Serbian forces withdrew from the territory, and included the precipitating NATO aerial bombing campaign launched on 24th of March 99 against Serbia in response to the ethnic cleansing of the war crimes committed by the Serbian forces. So therefore, this raises questions about the international administration operating at the time and their responsibility to offer a safe and secure environment for all people in Kosovo after the war. And since the above alleged crimes also occurred during a time when the UN mission and KFOR, the Kosovo force, were in charge, what does this tell us about the liberal peace framework which they implemented in Kosovo? Can one really divorce local accountability from the wider reach of international responsibility. So all these witnesses really emphasize the absence of evidence of crimes allegedly committed by the indictees, as well as the porous nature of decision-making within the KLA ranks, pointing to a lack of a clear chain of command. And the third point that I would want to raise is to sort of talk a little bit about sort of the wider ramifications of, what this case is doing in terms of setting a precedent for international relations in general, I would say, and international law and transitional justice. In the closing statement in early February this year, the prosecutor asked for 45 years of imprisonment for each of the 4 defendants, an extremely harsh sentence even by the standards of the ICTY, which had an average sentence of 15 to 20 years, I would say. The rare examples, extreme cases, include Radovan Karadzic, who was sentenced to 40 years in prison, or Ratko Mladic, life imprisonment. These men were part of the decision-making machinery, as we know, which under the leadership of Serbia's Slobodan Milosevic had committed the most heinous crimes in wars in Bosnia and Herzegovina and Croatia, of course. Mladic, for instance, was the architect of the genocide in Srebrenica, where more than 8,000 Bosniak men and boys were murdered in July 95. In response, as we know, the Thaci et al. Defense team has asked for acquittal, underlining the prosecutor's flawed arguments and lack of evidence. But beyond all these details, though, the case is about the victims, or it should be about the victims, right? The individuals who were allegedly killed, abducted, or tortured. Their families must hope that after 25 years, justice will be done, as this is, as was said before also by Afrodita, a basic tenet of transitional justice. However, I would say that looking back at years of judicial proceedings, testimonies, and evidence, there is little in the way of direct, concrete culpability for individual crimes. And in fact, the essence of the prosecution's case has been elsewhere, trying to prove a chain of command responsibility. In other words, the prosecution's focus has only partially been on finding individuals who killed or tortured people, which admittedly is a complex task. But rather, the case was about convincing the panel of judges that these 4 individuals, Thaci, Veseli, Krasniqi, and Selimi, stood at the top of that chain. And therefore, the whole case does not offer concrete answers to the burgeoning questions that these potential crimes raise. It offers a sort of justice that, being unable or unwilling to investigate the individual crimes of individual people, aims to find a guilty party in the form of an alleged enterprise to which it attaches all past wrongdoings. And by way of concluding, offering some remarks, I would say that this indictment really against the KLA leaders is part of the liberal peace framework, which supposedly seeks to bring closure to a transitional justice process in a post-conflict environment, right? And as such, this trial creates a potential precedent, I would say, in post-war transitional justice and more general in international law regarding the power dynamics between a full-fledged army and a guerrilla formation or liberation movement. If you really look at some of the questions posed by the prosecutor, and I echo what Gzim was talking about the sort of liberation movements in the future, is the threshold that is being asked of such liberation movements seems to be very high indeed. I think what you could read between the text is that, according to the prosecution, what they would want is really yes to the existence of a liberation movement, but ideally one which is perfectly structured with a very clear chain of command responsibility, with democratic accountability, essentially an armed movement which is really akin to a state army. And in conditions of apartheid, in conditions of extreme suppression, like Kosovo was in the 1990s, the answer as to whether the KLA could have been that kind of army, I think it's obvious. So it risks this case, I think it risks being perceived as a priori taking sides with repressive regimes and placing an unfair burden of proof on informal armies that may be fighting against them. Such informal armies, as the KLA case has proven, are far from cohesive, are far from well-organized structures with a clearly delineated chain of command. raising them to the threshold of formal armies to seek criminal responsibility from them as a structure risks a backslide into another kind of injustice, one in which individual crimes are left unaddressed, while an entire informal army is blamed in a single stroke. And lastly, I would say that looking ahead towards the near future, if acquitted, I think the verdict would expose the futility of the prosecutor's core argument, which insisted on attaching chain of command responsibilities to individuals in an irregular army. If the accused are sentenced, however, I think that the majority of Kosovars will likely not see justice in the verdict, but will instead see an attempt to turn the recent history of a liberation movement fighting for freedom and independence on its head. Thank you.
Thank you so much, Armand, Robert, Gazim, and Afrodita. I think we have quite a lot of food for thought. We have a few minutes, not a lot, but I would, as I mentioned, I am very glad to see that Aidan Hehir is here with us. And so, Aidan, I have enabled your mic and camera as well. So please share your thoughts with us as well, if you can hear me. Yeah.
Yeah, thanks, Dan. Can you hear me?
Yes, we can hear you. Yes. Hi.
Okay, thank you. Yeah, thanks to everyone on the panel. It's really good to hear people talking about it. It's amazing how few people have been talking about this for so long. You know, I largely agree with everything that has been said, so I don't want to repeat that stuff. You know, I published a report in 2018 that was based on workshops that we did in Kosovo with Serbs and Albanians, and very much came to the conclusion that the court was unlikely to have any positive impact on reconciliation, that the court was not engaged in sufficient outreach, and that it was actually likely to potentially cause societal unrest, and that it wouldn't contribute anything to Kosovo's future. But I just wanted to add something that I think is quite important. You know, everything that Robert said about the origins of the court are absolutely true, you know, in terms of it stemming from Russia and being obviously something that Serbia wanted to happen, and then going through the Marty report, etc. But I do think it's very important to remember that, you know, Tachi himself said that, you know, the establishment of the court was, he described it as a great injustice. And he said that he would not have supported the establishment of the court if it wasn't for the pressure he was put under. Now, he wasn't being pressurized to create the court by Serbia or by Russia. He was being pressurized to support the establishment of the court by the European Union and by the United States. So this court would not have existed had it not been for Kosovo's so-called friends demanding that this court be established. So it's a very important thing to remember as well that, you know, this court is a function of Russia and Serbia's determination to portray Kosovo as this criminal enterprise and to undermine Western engagement with the region, but that the West itself facilitated the creation of this court. It wouldn't exist without them. And therefore, you have to ask that question, why? Why is it that we're in this position? Why did they support it? And that comes back to the central point that many people have been making for many years, that the West is appeasing Serbia at the expense of Kosovo, and that the creation of this court has to be seen in that light, like the creation of the ASM, like the border deal with Montenegro, like lots of different things that the government of Kosovo was forced to abide by up until the more recent government that came into power. So it's very important to remember that as well, that this is testimony to the fact that the geopolitical international distribution of power has changed markedly, and the West is now increasingly supporting Serbia at the great expense of Kosovo, which has to, I think, make people think again about their support for the West, the blind support that some people have for the United States and the European Union within Kosovo. Thank you.
Thank you so much, Aidan. And you recently co-authored, right, a book on transitional justice, examining many of the aspects of this important topic. If there are no more questions from the audience, we are coming to the conclusion. I just want to give the opportunity to our panel if they want to react to anything at the end. If you have anything. No? With that in mind, I just want to extend our deepest appreciation to Gazim, Afrodita, Robert, and Armen, and also to Aidan for participating in this webinar, sharing with us their thoughts. Again, this was a reflection on Kosovo's specialist chambers. We thought this would have been a good moment after the process ended to allow for more, I guess, free exchange, we can say, not to be in any manner perceived as trying to impact the process whatsoever. So, as Armen said, intellectual conversation on this topic with people who have written and researched and are looking at the impact of this process will have on Kosovo, the region, and as we said, the wider, perhaps wider cases. The webinar has been recorded, and we will, based on consultation with panel, we will disseminate it via YouTube channel, so it will be available for those who have not been able to join us. Again, thank you everyone, and have a great rest of the day and a great week ahead. Thank you again. Bye-bye.
Thank you very much.
Thank you.